dignitaries, teachers, teams, witnesses, and all the other attendees. I, Ghazal Gupta, feel privileged to host this session and extend my warm welcome to all present here for the inaugural ceremony of first Manipal Trial Advocacy Competition organized by School of Law and Lex Logical. We feel honored to host each and every one of you, and we extend our hearty vote of thanks to Justice J.K. Ranka sir and Professor Srinivasulu sir for gracing us with their presence. I would firstly like to call upon Mr. Amit Yadav sir, the faculty coordinator of Lex Logical Club. Amit sir has vast experience in legal academia. Presently, he is associated with Manipal University, Jaipur, as an assistant professor at senior scale. He is an external member of the Academic Council and Board of Studies of Dr. K.N. Modi University, Tonk, and is associated with Rajasthan Public Services Commission for various assignments. He has been invited as a resource person in various national and international seminars. He is a man of distinct vision, a fountainhead of illuminating ideas, and an inspiration to all of us. Welcome, sir.
Thank you, Ghazal, for such a nice introduction. Uh, before commencing my formal welcome to all dignitaries, I just want to quote a quotation by Napoleon Hill that every adversity carries with it the seeds of equivalent or greater benefit. So during this pandemic situation, the entire human race experience this thought, this objective of Napoleon Hill, that although there is a apada, but we converted it into the avsar, and for that reason, I am happy that we all are here and able to gather with this virtual platform. And I just want to welcome from the core of my heart to Honorable Justice Mr. Justice J.K. Raka, former Judge of High Court, and Honorable Srinivasulu Sir, Professor WBNUJS Kolkata, for being with us. And always, I just want to again thank to Justice J.K. Raka Sir that he is always ready to guide us, to support us, and to push us towards the legal excellence. So, sir, I would like to basically convey a brief introduction of the Lex Logical Club. So, this club is basically we can say that it's the oldest club of School of Law as well as the Manipal University, Jaipur, and this club has basically you can say that functioning very effectively, rapidly, and more than 60 events within a year. This club organized. This Lex Logical Club has organized, and we can say that it only could be happen because the objective of this club is to the student, for the student, by the student. So every activity which has been done under this club is basically for the purpose to uplifting the student, for purpose to enhancing the knowledge of their the legal academia as well as the legal experiences. So for that purpose, this club is functioning under the apt guidance of our honorable leadership, and especially our honorable director ma'am, Professor Dr. Vijay Lakshmi Sharma. And uh, not taking much time, I just want to thank to all the August gathering who is presented here, and I wish that this first national trial advocacy for his success. Thank you, sir. Thank you. Over to you, Ghazal.
Thank you, sir. Now, I would like Aditya to please present the video, a short video of all the events we have conducted with the leadership of Ma'am, sir, and J.K. Ranka, sir. members, teachers, and students of School of Law and Logical for this fantastic work, and we hope to continue the same in future. Now, without any further ado, I consider it a great honor to welcome Professor Dr. Vijayalakshmi Sharma Ma'am, Director of School of Law, Manipal University, Jaipur. She has a rich and versatile teaching experience of over 17 years. During her illustrious career, she has efficiently and diligently shouldered administrative and student welfare assignments, and has also doomed multiple caps of different hierarchy within the university effortlessly. She is an idol of knowledge and experience and the guiding light of the students. Welcome, ma'am.
Okay. Thank you so much, Gazar. Thank you for this warm welcome. Thank you. A very good morning to one and all present here. Pandit Jawaharlal Nehru very well said, measure of a man is not where he stands in the moment of comfort and convenience, but where he stands at the time of challenges. So with these words of appreciation for each and every stakeholder of this event, I would like to welcome, as instead of all the challenges, around 30 teams has participated in first Manipal Trial Advocacy Competition 2021. On behalf of School of Law, Manipal University, Jaipur, I welcome our honorable chief guest and special guest on this occasion. I welcome Justice Mr. J.K. Raka, former Judge, Rajasthan High Court. I welcome you, sir, as sir's theory is very simple. Sir believes that do not wait for the perfect moment. Take a moment and make it perfect. Sir, we all are very much blessed with your guidance and your support. Sir, you are always there for each and every activity or for each and every guidance which is required for School of Law, Manipal University, Jaipur. Words are very short to say anything about you and your generosity. But yes, I would like to mention here that from the beginning of the journey of School of Law, Manipal University, Raka family is always there. In the year 2015, we had started the journey of Manipal Raka Moot Court competition. And this time, the international moot court competition was recently held with the help and guidance of you, sir. So we are thankful for your gracious presence here, sir. Thank you. I would like to welcome our special guest, Professor Dr. Srinivasullu, Professor of Law, National University of Juridical Science. We welcome you, sir, and we are really honored for having your presence here on this platform. Thank you for being with us. I welcome all the participating teams, witnesses, moderators, faculty members, and law students. I would like to mention again my deep sense of gratitude for all the dignitaries and esteemed guests. Sir, School of Law, Manipal University, Jaipur always believes to develop and enhance the practical approach of students for evolution of law as an instrument of social change. And I am very pleased to share that the contribution of law students are tremendously remarkable. So I think a big round of applause for the law students of Manipal University. Sir, as one of the best and leading college in Rajasthan, Manipal University, Jaipur is dedicated to provide best education in terms of legal and societal aspects, especially with the help of honorable judges, advocates, legal luminaries, and the academicians. The high degree of scholarly interaction between the students and teachers in the classroom makes this university or this school of law one of the best law college. Sir, I must acknowledge our leadership of Manipal University, Jaipur, as we are very fortunate and blessed with the guidance and the support of the leadership of Manipal University. I would like to acknowledge the support and the contribution of our President, Professor G.K. Prabhu, Pro-President, Professor N.N. Sharma, Registrar, Professor H. Ravishankar Kamath, all deans, directors, head of the departments, faculty members, and all students for their contribution for making this event a success, a great success. Sir, one thing which is very important, and I think this is only the platform where I can share with all the participants and the dignitaries, that is Manipal University, Jaipur is having a very innovative idea to develop and enhance the quality of the students, and that is club formations. So we are having more than 50 clubs in overall Manipal University, and 4 dedicated clubs are working under the flagship of School of Law. So these are Legal Aid Clinic, this Lex Logical Club, Human Rights Cell, and the Consumer Protection Club. So one of the club, it is Lex Logical Club, faculty coordinator, Mr. Amit Yadav, Ms. Ghazal, Mr. Aditya Gupta, and all the members of Lex Logical Club. I am thankful to one and all members of this club that they could do and they could they could make this event a great success. So again, I must congratulate to one and all participants. And for the participants, please listen me. As nothing great can be ever achieved without enthusiasm. So don't think that you are on the platform where nobody can see you. Please try to make yourself a very good participant in overall competition, so that you can make it a great success, and your participation is itself an achievement. Don't wait for the final rounds, or maybe you will be win or lose. Don't think about that. Your participation itself is your achievement. So thank you so much, Ghazal, and thank you so much, Raka sir. Thank you, Professor, for being with us. Yes, thank you, Ghazal. Over to you.
Thank you for your kind words, ma'am. Now, I am profoundly elated to take this opportunity to introduce our chief guest of the day, Justice J.K. Ranka sir. He is a former judge of High Court of Rajasthan. He has been in association with us for a very long time through conducting the famous Ranka Moot Court competition. He has always guided us and is a distinguished mentor to a lot of students. We welcome you, sir, and we wholeheartedly thank you for always being an inspiration to us.
uh, good esteemed Professor Dr. Srinivasulu NS, Professor of Law, University of Juridical Sciences, Kolkata, respected Professor Vijayalakshmi Ji Sharma, Director, Manipal University, Professor Amit Yadav Ji, Professor Pramrit Singh, my young students, Aditya, Ghazal, Bhavna, and so many young friends, energetic friends, vibrant faces. This morning, I am happy and delighted to be with you all this morning. And first of all, let me wish you all a very happy our new year, which commenced 3 days, 4 days back. And may in this new year we achieve all good things, happiness, prosperity, and this pandemic no sooner gets over. Professor G.K. Prabhu, President, Manipal University in absentia, I think. Dr. N.N. Sharma Ji, Dean, Manipal University in absentia. Such a nice way to begin with showing a video of 60 events culminated during this year of pandemic by the Lexicological School of Law, Manipal University. Highly, it's incredible, commendable, and I am happy under the leadership of all the Professor Prabhu, Dr. N. Sharma, Vijay Lakshmi ji. The students are excelling, certainly in all these fields. One day when dear Aditya came to me about this trial advocacy, I said, I am already part of you, as Manipal has been close to my heart, close to the heart of my father, close to the family. And I'll certainly be there assisting you and in all endeavors of yours. But he said that, sir, we request you to be the chief guest of the inaugural session. I can never say no to my young friend, and wherever and whenever an opportunity arises, I make it a part to join these webinars or conferences, because one thing, whenever I meet young friends, I become young at heart. Of course, I am otherwise also. But I too learn many things by on different subjects and different topics. Remember, my friends, learning never ends. And whatever may be the age, one has to learn, unlearn. And life teaches us so many things every day, which should be learned, taken to heart. And all good things should be taken and carried forward in life. And whatever drawbacks are, they deserves to be forgotten or erased out of your life. With the Manipal University, the future of my young students who are studying in Manipal University and elsewhere, of course, there are so many teams participating in this important webinar on trial advocacy, which should have been organized by majority of the colleges, because I feel this is ultimate insofar as a lawyer is concerned. Well, friends, whenever you enter a profession, my first suggestion to you would be, whenever you complete your law, the first aim of yours should be to be a litigating lawyer. You will serve the society by becoming a litigating lawyer no sooner you enter the profession. And one more important thing to all of you, all students who are in this webinar, wheresoever you located, as far as I am also concerned, the first thing should be that whenever you complete law, don't rush up to appear before a high court or a supreme court. Begin your humble journey, noble journey from the trial court premises. I, for myself, have gained successfully because my mentor and my father said, if you want to be a successful lawyer, irrespective of any stream of law where you practice, go and look to the proceedings being taken up in trial court, the law of evidence, how it works, art of cross-examination. They are taken care of by at the trial stage only. Later on, only the appreciation, evidence is appreciated. But what is the art of examination, cross-examination, I'll deal a little bit later. But I am giving my advice to my younger generation that you will have umpteen times to go before the High Court and Supreme Court, but spend at least 1.5 years of your journey as a trial court lawyer. Join a good office of a civil and more particularly a criminal lawyer who would be conducting trials insofar as Section 302 or any other offenses, because the best of the cross-examination art comes from those very cases. And then civil law also requires that at times, in majority of the cases, evidences are recorded. Of course, that art is now slowly dying down because now initially an affidavit is filed, but then of course art cross-examination still remains. But the rigor of the real thing, which was about 5 years or 7 years, 10 years back, has come to a little halt. But nevertheless, whatever the law is, we are bound by the Constitution, and all my students should, and every citizen of the country should know and be guided by the principles of the Constitution. The founding fathers created this Constitution, which had almost taken guidance from more than 200 constitutions of world over, I think. Nevertheless, it is considered to be one of the finest constitution. Of course, with times, things should change according to the current atmosphere and all. Well, friends, yes, as you all know, the trial commences no soon a suit is filed or an offense is committed at any place. A person who wants to assert his right, he has to file a suit, or if an offense has been committed by any person, then immediately the matter goes before the first stage, or so we call it as a trial court. In high courts, except writ petitions or a few other matters, but by and large, 99% of the cases come up from the trial stage, trial court. And that is the best skill, because whatever pleadings are there, whatever plaint is there, whatever complaint is there, they take up the shape from that stage itself. Later on, it is only appreciation of evidence. How best a trial court lawyer thinks best of his client as to how he would be taking up its case, who could be the witnesses, who could be the, what could be a proper reply, plaint, so that the ultimately the client gets the best benefit and succeeds in the case or otherwise. Insofar as criminal trial is concerned, an offense is committed, with recording is there, then it goes to the magistrate or the trial court, a CJM or whatever the level of authority is. Charge sheets are filed, witnesses are produced, and then the trial begins. And all these things come up, and my friends, whatever evidence is recorded, as I've already conveyed, at the first stage, in the higher appellate fora, maybe High Court or Supreme Court, all that very evidence is considered as coming up from the stage. In High Court or Supreme Court, those evidences cannot be brushed aside or altered or changed or for any other, because whatever matter has been recorded, whatever pleadings are there, they remain as it is without any change of even a single word. Whatever thing a trial court lawyer does is ultimately the gospel truth insofar as that file is concerned, that case is concerned. So the trial court lawyer is the ultimate judge to see as to how the things would shape up insofar as the case is concerned. And insofar as criminal trial is concerned, of course, proceedings are so slow, and it deserves to be slow because liberty of a person or of an accused is to be considered. And that is prime consideration insofar as our constitution is concerned or otherwise. And I also feel, and so many people feel, that why the trials go on for 15, 20 years, that is certainly bad. But things as they are, the other side, the accused, try to uh, delay the proceedings because that is ultimately to its advantage. Because there are many things are there over the time, witnesses have to come again and again, and they turn hostile far as the criminal matters are concerned. The witnesses are won over by the accused side for diverse reasons, monetary or pressure, and villages you know for certain that why how poor villagers they either do not turn up for once even becoming witness, even in criminal cases they don't turn up for want of pressure tactics or coercion from the other side, the side of the accused. This is the system which is prevailing, which is very bad, but whatever it remains, we have to face the situation. My friends, you must have noticed today in one of the papers I could just glance, insofar as our politicians are concerned, the mentors of the constitution, lawmakers are concerned, it is the height of things that it was reported, and it is on record also, that out of about 750 member of parliaments, both sides, almost 200 are having criminal cases on them. And if and MLAs are concerned, they are today also it is reported that every fourth MLA in Rajasthan is having criminal cases. Every two MLA in Madhya Pradesh and many all other states, a similar fashion is there, similar situation is there. And they make the law, and we are bound by that law. Is height of in this country that we are facing this situation because and they get the trials delayed for all these ulterior motives, winning over and all. So these things with my young friends coming up in later in life in profession should take up care that these things die down gradually, good people come up so that our country prosper and move ahead insofar as the real life is concerned. Well, friends, a little about art of cross-examination, which is a very important tool, as I have already mentioned initially, for a most important tool for a successful lawyer, and is available at the first stage itself and not later. And the evidence recorded at trial or initial stage is appreciated by the higher appellate stages but cannot be changed. Therefore, to all my students, the law of evidence takes care, section 135 to onwards to up to 164, 3 or 4, about how the cross-examination, examination, re-examination takes place. Cross-examination can make or destroy a case. It is a keystone to a successful trial. The purpose of cross-examination is not simply to attack an adversary, but to strengthen your case. Examination of witnesses is very important for any case, whether it belongs to civil or criminal. and both the procedural law explain the examination of witnesses. Effective cross-examination can make the difference between winning and losing trial. Although cross-examination can be part of trial, that is the most fun for experienced trial lawyers. But preparing good cross-examination takes a lot of thought and hard work. Cross-examination is considered to be ultimate test of an advocate's skill. Many cases have been won by virtue of cross-examination. Even the noted celebrity Ram Malani, Nanipal Kiwala and all celebrated lawyers of the day, they even could thresh out the evidence, and it was reported and successfully also that even a wrong evidence recorded, Nanipal Kiwala, Lani and the lawyers of their repute could shatter the evidence recorded, and even the best of cases like murders or otherwise, their clients, they were able to successfully absolve their clients. But that is once you gain experience over the time that these things can happen. There are a number of important judgments, and you will find once you go up in life about and majority of them on criminal side. But that holds good insofar as even civil matters, because all these things which have been guided by or observed by the Honorable Supreme Court of India, which becomes a law of the land, is binding on all other authorities, and whatever High Court has stated insofar as that particular state is concerned, all the lower authorities are bound and the state is bound by those findings or observations of the High Court. And insofar as Supreme Court is concerned, it extends to entire country. Insofar as this evidence is concerned, because the trial advocacy, I have gone through the problem also, which has been very nicely drafted by the maybe young students of Mr. Yadav, and real thing would come out, because what I feel that insofar as this trial advocacy webinar is concerned, apparently what I feel that it will make out like a moot court, because the skills of both the sides insofar as the for and against, one would try to uh, safeguard the accused. One would certainly say no, he has committed the offense, and ultimately the best of argumentative skills would come when the proceedings would continue today, tomorrow, and day after. And such a nice poser has been given to the students, and it will certainly help them develop and give their best of arguments. One more important aspect which I would be covering is, very often the words are used relevancy and admissibility. Very two important words in the trial. More or less, it appears that it is almost synonymous, relevancy and admissibility. But insofar as criminal trial is concerned, or law of evidence is concerned, whatever there may be similarity or synonymous words, but it has wide difference insofar as trial is concerned, because and their legal implications are distinct and different from for more often than not. Facts which are relevant are not admissible. So also facts which are admissible may not be relevant. For example, questions permitted to be put in cross examination to test the veracity or impeach the credit of witnesses, though not relevant, are admissible. The probative value of evidence is the weight to be given to it, which has to be judged having regard to the facts and circumstances of each case. So whatever an advocate may feel, yes, I have a good case, but the other side may uh, weaken the case if the other side, other lawyer have the art of cross-examination, shattering your own case, and that is what happens day in and day out. And therefore, whatever extreme one may practice, my suggestion to you and guide to all my young friends is that law of evidence is of utmost importance to each one of you, each one of us, and that would read over law of evidence again and again, and you will certainly find that even after fourth reading, you may come up to a different conclusion. What a lawyer, brainy lawyers do, that and good lawyers I have seen, that irrespective of their acumen or brilliance, on the day of argument, on the day when the matter is fixed, they will glance over again the law of evidence despite 30 years of practice or 35 years of practice. And that should be the endeavor of a lawyer, because you are giving, you would be giving, rendering service to the client who has come to you for his own grievance or otherwise. So, of course, protracted evidence leads to delay, that I have already conveyed, but these are all part of the justice delivery system. And once it is part of constitutional evidence or criminal trial, they go hand in hand. And of course, now I'm seeing that the younger generation, especially 5-year law students, are doing tremendously good work. And during my tenure also, I had with me many young lawyers. Within 2-3 years of their practice, they were doing so well. And one more aspect which is available to my students, of course, it is going off the track, that what I have stated earlier, two fields should be chosen by each one of you. First is litigation, and the second is judicial services. By both, as a litigating lawyer as well as entering judicial service, you are giving service to the society. Once you enter judicial service, at the first stage itself, you would be giving divine duty, which the God has given to you, everyone, that you would be imparting justice to a litigant or the other side who has come before you. And there are plenty of scope available insofar as judicial services is concerned, because and of course particularly for my young female lady lawyers are concerned, they have a great opportunity, because what I have noticed in the last 7-10 years, 7-8 years, not only in Rajasthan but elsewhere also, that 2/3 of the female participants, female, are being selected in judicial services. And maybe after 7-10 years, one will see that females are dominating insofar as not only the lower courts but higher court, high court also. Today also, one must have noticed the grievance of the Honorable Chief Justice of India insofar as females are concerned, that they are finding it difficult, the lady lawyers, to come up in profession. And I don't know why, for in this 21st century, the lady lawyers should say कि मैं तो घर गृहस्थी में भी हूँ, I can't give time to by becoming a judge and all. These things are of past. One has to move ahead, and certainly his grievance would be is correct. If the good lady lawyer says after 20 years of practice, excelling in profession, to say कि sir, I would be busy with my family, busy with my children. Uh, there are examination of my daughter in who is in 12th year or 10th year. These according to me should not be taken care. These are now good times. Whatever opportunity comes to a lawyer, that should be accepted, because you are, once you reach the higher pedestal, you give the best to the society, and serving to the society should be the ultimate aim. With this, I think I have taken whatever time was needed, and may have explained something about the trial advocacy, but this is most important topic, and certainly the organizers have thought it appropriate for bringing out the best talents, and certainly it ultimately on the day of valedictory, Madam Vijay Lakshmi ji and Amit Yadav ji and all students would feel कि ये तो मूड कोर्ट से भी ज़्यादा अच्छा रहा. That has that would come out when the students would argue on the final day, semi-final day, that what certainly it is taking the shape of a moot court. With all good wishes to my younger friends, blessings to all of you, and certainly, madam and all, I am always available for any cause, because, as I have said, I also learn many things whenever these webinars are there or conferences take place, because once Aditya came to me, it was really because I began my journey 40 years, 45 years back. I went into my memories कि मैं कहाँ से शुरू किया था मैंने. So it again revived all good things कि मैं क्या क्या वहाँ पे क्या सीखा था, क्या वो ट्रायल चली थी, कैसे क्या हुआ था. So I went back to my memories, and then again, of course, my personal experience, of course, later on, because I was a taxation lawyer or a corporate law lawyer, but it helped me even in taxation, because Section 131 witness proceedings are there. In taxation, cash credits issues are there. Bogus purchases issues come up. So this helped me to a large extent, this art of cross-examination or examination or re-examination. Because even in taxation law, there are issues which arises insofar as this cross-examination or otherwise is concerned. So thank you very much, Madam Vijay Lakshmi ji, Amit Yadav ji, my young friend Aditya, Ghazal, Bhavya, and so many other young friends in giving me time to do my homework and research and say something to you on this topic. All the best to the student teams, and I am sure everyone would excel in their best argumentative skills, which will later be proved when they come up in profession. Thank you. With all good wishes and blessings. Jai Hind, Jai Bharat.
Thank you for your informative words, sir. I'm sure all the students have learned a lot from your experience. Now, I would like to call upon Professor Dr. Srinivasulu sir. Sir is a professor of law at National University of Jurisdiction, Hyderabad. He is also associate director of advocacy at Advocacy International. He has completed distinguished works in various capacities and various institutes of international law, Ontario, Canada, London, Singapore, Switzerland, Singapore, Inaugural, 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 Inaugural,
Uh, Ma'am, I think there is some network issue. She is joining in a few minutes.
Okay.
I'm really sorry, sir. I think there was some network issues.
Yeah.
Professor Dr. Srinivasu, sir, is a professor of law at National University of Jurisdiction Science, Kolkata. He is also an associate at Justice Loving Friendly Organization, Japan, a distinguished professor at Canadian Institute of International Law, Ontario, and a distinguished member at the International Council of Jurists at London. He has completed distinguished works in various capacities, and we are extremely elated to have him here. Thank you, sir, and we welcome you.
Thank you. Thank you, Ghazal. Respected Justice Ranka ji, the principal, faculty, staff, and students of School of Law, Manipal University, and also the young participants of this particular National Trial Advocacy Competition 2021. Perhaps legal education has come across a number of fascinating reforms, and this trial advocacies, moot courts, clinical programs, all these have been added to the legal education spectrum of late. Probably in the later parts of 1990s, I believe, Bar Council of India, with the support of learned people, justices like Justice Ranka and all, thought that legal education should also become professional and pragmatic. Earlier to 1990s, legal education was, in general language, legal education was all about civil law and criminal law, and some type of education which only can be perceived by those people who are already settled, or who would like to settle in the way they like to. I mean, the people who are coming from elite background, they only used to pursue legal education because it will take a lot of time to settle down in life, or it was meant for those people who would like to take their own time in getting things done, settled, as far as their profession is concerned. Number one. Number two, legal education was meant for those people who could not get through engineering, medicine, management, and the kind of professional courses. So those people, those students who could not become an engineer, doctor, or even a manager would end up becoming a lawyer. So this was the pathetic condition that legal education was having in the say in 70s, 80s, and also in the beginning or first half of the 90s. Probably because of this reason, people thought at the realm of affairs that there is a need to pragmatize, professionalize legal education. And in the 1998, Bar Council of India came out with this reformations by introducing new subjects which are which you call as clinical papers, moot courts, pleadings, draftings, legal aids, and also trial advocacy kind of skill development oriented program, right? It's about developing your skill of argument, skill of pleading, skill of drafting, skill of reading a judgment, and also skill of writing a judgment, right? We nowadays in the past 5 to 7 years, of course, people are talking about skill development a lot, right? They talk about skill development at the different platforms in every discipline for that matter, or every field for that matter. People talk about skill development, what kind of skill that you have actually acquired, right? When we attend classes or when we go to library and read up books, we acquire knowledge, we gather knowledge, and that knowledge, information may not be skill, right? Whatever your teacher teaches you in the classroom, right, theory, or whatever you end up learning by browsing in the internet or by going physically to library, whatever. All that is part of gathering information or acquiring knowledge. But that doesn't mean that you have acquired the skill. So there is a serious change between what you call as information, knowledge, and the skill. Knowledge is all about gathering information. You know the subject, right? You know the subject, you have the information, and that you call as knowledge. Knowledge will have to get translated into or transformed into skill, right? And that transformation takes place through this kind of moot court competitions or clinical trials or your trial advocacy programs. So development of your knowledge or whatever information that you have gathered, if at all it has to become a skill in the for the purpose of ending up becoming a lawyer, judge, or any other professional pursuit for that matter, how exactly that transformation takes place, how exactly the knowledge becomes a skill, right? And for that, what you need to do. And because of this reason, Bar Council of India happened to introduce these clinical papers. And by virtue of that, in the past 20 odd years, right, we get to see every day or probably every second day number of different types of moot court competitions or trial advocacy programs getting organized, because students are learning more through these kind of activities or programs than in their classrooms, because in the classroom substantially it is theory, right? And or in the library, whatever information that you gather, it will be basically theory. And of course you may get some books, some knowledge, some material with respect to how exactly you go about mooting, how exactly you go about participating in trial advocacy, how exactly you go about debating and all that. Again, it is theory. Theoretically, somebody has explained or analyzed how exactly you can go about conducting or participating in these kind of programs. But it is up to you how exactly you go about, because being the students of law, you must be knowing it very well. The way you talk, the way you walk, the way you conduct, the way you articulate, all is part of your personality, right? Personality. Justice Hegel happened to propose this theory, personality theory, under the jurisprudence. You must have studied it, right? Wherein he says that the individual's personality gets into the way that individual perceives law, that individual interprets law, or that individual gives a judgment, right? Judicial reasoning also depends upon the judicial officer's personality and personal social background, right? So in the similar way, the way you actually go about if you participating in trial advocacy program, or the way you argue, the way you go about pleading, all that is based upon the kind of person you are, the kind of personality that you're actually having. And this the personality expression, personality extension, whatever you get to see in these types of programs where you actually participate as a pleader, as a trial advocate, or as a matter of fact as a judicial clerk, whatever, right? You are actually extending your personality. And how that personality gets extended, not just because of the knowledge information that you have gathered, but because of the knowledge information whatever you have transformed into the skill of argument, skill of pleading, skill of conducting research and all that. And that skill acquisition or skill expression, skill execution, of course it is part of your copyright law, right? The copyright law talks about it, that any expression for that matter which is executed on any particular platform, it could be physical platform or a digital platform, right? It is a subject of copyright, right? It's a subject matter of copyright law. So such being the case, the skill whatever you are trying to acquire, the skill that you are trying to develop in terms of litigating, or in terms of you putting forth your arguments both orally and as well as writing, that is part of this new reforms whatever Bar Council happened to initiate in the later part of 1990s. And today 2020 and 2021, it has become very clear that students of law learn more in these kinds of programs in their classroom. Of course, I'm a law teacher, right? But I don't hesitate in saying this, that students learn more in their internships. Students learn more in these kinds of debates, competitions, trial advocacy competitions, and moot courts, because it is the platform for developing the skill. Because at the end of the day, you need to acquire skill. You are not just supposed to have the knowledge or for that matter information. For example, from past 1 year, because of this COVID pandemic and all, everything is online, right? Everything is online. Classes are online. Even this kind of programs are online. Examinations are online. And we have been, as a teachers, we have been given instruction that the question paper whatever you set should be completely problem based, no theory. You should not ask any theory based questions, or you should not ask any descriptive or essay type questions. You should test the skill of the student by going about prescribing only problem based questions. So earlier to that, of course, we used to have problem based questions, but we used to divide it, right, in terms of preparing. We used to go about preparing a combo kind of question paper where we will put in all types, different types of questions, problem based or advisory dossiers, essay type, short note, all that. But now, because of this pandemic, at least in our national law schools, it has become a new normal that the question paper will be completely problem based. The question paper will be only for the purpose of testing the skill of the student, not the memory power, right? When I say memory power, whatever knowledge, whatever information you have gathered through your classroom, or through by reading through your study material, or by spending some time in the library, reproduce it, or rather you can vomit it. But that is not the job of a advocate, because advocacy is all about acquiring a particular type of skill. As Justice Ranko was mentioning, the skill of chief examination, skill of cross examination. In fact, the real advocacy depends upon the way you conduct the cross examination, because you are going to rebut, dislodge already the established fact, and as well established law. By through your cross examination, you are going to dislodge that. So the skill of you understanding the psychology and the personality of that individual who has been presented in front of you, for you to go about cross examination, and the kind of personality you are, who is equipped, right, who is having the enough skill to dislodge the already established fact and law through the cross examination, all that is part of your skill. And how exactly that skill you have developed, it's not just purely based upon the knowledge, information that you have got, but how exactly you apply it, right? Application of the knowledge, application of information for solving a particular problem, for achieving a particular task. In this case, you want to cross examine a client, or for that matter under trial, or you want to conduct a chief examination. So that is a task. So for the purpose of completion of that task, how exactly you are going to apply the knowledge that you have got, how exactly you are going to apply the information that you have got. So application of knowledge in terms of science and technology, we say that technology is nothing but application of scientific knowledge, right? Science and technology we sometimes use as synonyms, but there is a great difference. Science is all about having information, knowledge, and technology is all about applying that scientific knowledge. So application of scientific knowledge results in technology, right? So similarly, application of legal knowledge, legal information results for solving a particular problem or task, results in skill. That skill could be skill or art, whatever you call it as, skill of you conducting the chief examination, cross examination, skill of you developing the pleadings, argumentations, both orally and in written form. So this kind of skill we are talking about. This kind of skill you students are supposed to acquire now, not just for the purpose of coming with winning scores in these kinds of trial advocacy programs or moot courts, but as well it should help out at the end of the day, whenever you end up completing your education and end up becoming a lawyer, judge, or even if you take up a corporate lawyering or law firm oriented job whatsoever. So it's nothing but the skill development which is very much required, and the skill development takes place, or the nurturing of this skill is very much required, and which is actually taking place through these kinds of professional and pragmatic clinical papers, whatever we are supposed to study and offer as part of the new generation of legal reforms in this context. I have one very interesting issue to say here. Of course, we are now going about 5 years LLB, 3 years LLB, and all that in India, right? And wherein we have tried our level best to have these kind of skill development oriented papers, our subjects and all. But at the same point of time, if you compare Indian legal education or legal education, the structure of Indian legal education with any other foreign universities or legal education, how it is imparted over there, there is huge difference. For example, we have been offering 1 year LLM from past 7 or 6 years, which is completely based upon the LLM that is offered in UK. But when you compare the syllabus between the UK 1 year LLM and Indian LLM 1 year LLM, there is a huge difference. We again talk about certain common papers, things like that. Then only towards the last semester we end up giving that super specialization paper. But whereas it is not in case of UK and USA. Similarly, in our LLB programs also, we are now saying that rather boasting that we are offering clinical papers, and legal education has become professional, pragmatic, and we are skill oriented profession. And at the end of the day, we are acquiring skill, and with that skill development only, we are able to achieve our different tasks and settling down in our profession and all that. But you are spending 5 years here, but rather in other foreign universities, you don't need to spend that many years, and you are studying 50 papers. Probably you may end up reading 50 legislations, 500 legislations. You might have consulted some 5,000 different resources. Whether all these subjects, papers, legislations, or resources, whatever you consult, whether they are coming to your help at the end of the day, when you are ending up developing your skill, or when you end up becoming a lawyer, litigant lawyer, or corporate lawyer, judicial officer, whatsoever, whether that knowledge, whatever you are gaining, is actually helping out at the end of the day. To what extent knowledge and information, whatever you have gathered, is converting into skill? So that post-mortem we need to conduct, and by doing that, we have actually submitted a proposal to Bar Council of India that legal education need not be 5 years. Legal education should be 4 years. And in these 4 years, you need to filter out certain things which are not at the end of the day getting converted into skill development. Right? There is no time today. Nobody is having time. Right? We need to be bang on target. What you actually need to learn, what kind of skill you need to acquire to become a lawyer, to become a judicial officer, or to become a corporate lawyer whatsoever, right? And we need to be bang on target. We don't need to waste time, right? It's not just about acquiring knowledge and write books, or you gather too much of information and keep it in your brain, right? What is the use of that kind of information, knowledge, if that is not getting converted into skill? What is the use of that kind of knowledge, information, if it is not at the end of the day coming to your help whenever you end up becoming a lawyer or a judicial officer whatsoever? So our proposal, we are trying to filter out certain things by which we are trying to give a complete altogether different picture for the legal education, wherein more and more focus orientation is given to these kinds of papers, where the skill development or skill orientation is completely or professionally felt. I'm not saying that we have certain subjects which are junk. I'm not saying that we have certain subjects which we are actually offering in legal education which should not have been offered. But we are talking about the kind of skill you need to develop, and let us focus more on such type of paper or such type of subjects, which will help out the student at the end of the day, whenever he or she will become a lawyer, judge, whatever, whatever they would like to become at the end of the day. Whatever knowledge that you gain, whatever information that you actually end up gathering, should get converted into skill, and that the skill should end up helping you at the end of the day after you get graduated. So with that complete skill orientation, we are trying to reform further legal education for the purpose of ensuring that legal education is not just a professional pragmatic, but it is completely skill oriented. And I believe these kinds of trial advocacy competitions, or moot court competitions, debate competitions, which our law students are actually getting into more and more by day, would actually help them in not just gathering information, not just learning some knowledge, but in converting that knowledge, information into skill, and in acquiring the skill, which is very much required for them to when they intend to become a successful lawyer, a successful judicial officer, or a successful law firm or corporate lawyer, in whatever way they would like to pursue their professional career in future. Thank you. Thank you very much.
Thank you for your illuminating words, sir. It was an honor to have you as a guest. So, with this, we move towards the end of this inaugural ceremony. On behalf of Flexological Club and School of Law, Manipal University, Jaipur, I extend a hearty vote of thanks to our guest, Justice J.K. Ranka sir, and Professor Dr. Srinivasulu sir, who spared time from their busiest schedule to grace us with their presence. I am also thankful to the authorities of Manipal University, Jaipur, authorities of School of Law, Manipal University, Jaipur, and our director, ma'am, for helping and supporting us throughout the preparation. Today, we had an opportunity to hear their views, and I am positive that this will surely encourage us in our future endeavors. I hope the words of wisdom imparted by our guests and esteemed teachers will prove to be informative and insightful for all our participants. I am thankful to Dr. N.M. Ramka sir for being the guiding light of the School of Law, and we'll always remember you, sir. I would also like to thank all of our attendees for paying their valuable attention, and not to forget our team without whom this event wouldn't have been possible. Thank you. Have a nice day. Stay safe. Also, all the teams and witnesses, kindly note that the witness concreting will begin at 11:30. Therefore, kindly join the link on time. Best of luck to the teams. Thank you, everybody.
Thank you, sir. Thank you, ma'am. Thank you, Professor, sir. Professor Srinivas. Thank you, Nagas.
God bless you all.
Okay, Adit. So all set. Okay. Best of luck.
Yes, sir.
Okay, Ghazal.
Thank you, sir.
Thank you so much.
Thank you, sir.
Adit and Ghazal, you
Thank you,
put
sir.
a juggernaut effort, है ना? और ठीक है. If you have any problem, just call me. Okay. Thank you.
Sure, sir.
चलो.
Thank you, sir.
Thank you, sir.
Best of luck.